Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. I'm looking at an important book today which affects everybody because it's about an issue which is emotive, difficult, very topical, very contemporary, and it's actually about the legal system as well, about our current common law system and the system of Sharia councils and various other things associated with that particular culture. The book that we're looking at is this book here. It's called Choosing Sharia. It's got a subtitle, Multiculturalism, Islamic Fundamentalism and Sharia Councils. Been written by Machteld Z, and it's a paperback from 11 International Publishing based in the Hague. Now, we've got quite a long review for this book, which Elizabeth and I have discussed, and actually Elizabeth has written most of the review. She's given it the title for our review, Two Kinds of Women, The Realities of Sharia Councils and Islamic Fundamentalism Within Western Secular States. And what we're really looking at here is where we're going with the whole issue of Sharia in certainly England and Wales. I'm not going to talk about other jurisdictions, but there are concerns which we're going to talk about. So let's look at the book first of all. Here it is, a paperback. There it is. There is the spine, and then there's the back. A little bit of information, and there's a picture of the author, Machteld Z. I hope I pronounced the name correctly. The book runs to just under 200 pages. There's an index at the back with page numbers so you can find things. There's a very detailed bibliography. This is a very scholastic work of high quality. And this is the front. There's the front page there. And then we've got some basic blurb concerning the ISBNs and so on. Then the table of contents shows you exactly what is being covered. There are three main parts you can see on the 2 pages. Then there's a bibliography at the back, as I've indicated, an index. There's an introduction at the start, and you can see again there's a lot of footnoting, so there's quite a lot of detail even in the introduction. And after that we get into the multiculturalist ideology. And then again you can see a huge amount of footnoting to justify assertions. And then running through, you can see all the way through. It's not a book that I found the easiest book to read, but this is not an easy subject. And there are reasons for that, because it's complex and it's actually being made more complex as time goes by. But let's see if we can get some idea of where we're going with the book. What we say is this: you can't tell immediately from the title, but this new book from 11 International Publishing is a meticulously researched examination of the belief systems and policies which emanate mainly from Sharia councils, which largely without exception and tacitly encouraged by multicultural attitudes aim to impose an alternative ideology in Western countries, deeply at odds, says the author, with Western moral and legal principles of equality, freedom and justice. Now you can see immediately where we're coming into this, because we have the established common law and the rule of law spread back certainly to 800 years with Magna Carta and earlier. And that has developed over what will before long be 1,000 years. And what is happening at the moment is that there are changes apparently being considered to take place. That's really where we come in. So one of the ways in which Islamic fundamentalism manifests itself in Europe is through Sharia councils. And that is a warning the author gives, adding that these councils have operated in the United Kingdom since the 1980s as a legal order that stands apart from British laws, which is very interesting because in terms of legal history, it's a relatively new change. For anybody of my vintage, going back before the 1980s as a lawyer, certainly as a law student, a very different type of approach was adopted at that time, which would certainly not cater for the bringing in of other types of legal approach to the common law itself. We have got common law and we have got equity, but you can see the the clear changes taking place. So how and why has all this happened? You may well ask, and many of the manifold answers emerge unnervingly from this book. The author's considered opinion is that the fundamental problem has been triggered by none other than the concept of multiculturalism, ostensibly the result of the West's long-held and hard-won traditions of tolerance, freedom and the rule of law. Negative comments on someone else's religion, in other words, are neither the prerogative nor the duty of the state. And we've always had freedom of religion and religious worship as a fundamental right, of course, in this country. Now, as indicated by the subtitle, this book examines in detail the tenets of multiculturalism, which to some has become a quasi-religion in itself, and the often unfortunate consequences generated by tolerance towards intolerance. Cultural differences are good, say the multiculturalists, as referred to in the first chapter, but if not, they should at least be tolerated. The book demonstrates convincingly that multiculturalism, with its inbuilt dogmas, can become an intolerant creed in itself. Now, the author, as I say, is Machteld Z, PhD, so Dr. Z, and she is a Dutch political scientist and legal scholar who's carried out extensive research, mainly in the UK, much of it conducted by open-ended interviews, for example, with selected experts in this area, ranging from academics and lawyers to members of the House of Lords. We're very grateful to her for the work she's done. It is a great scholastic effort, and it's got important points, of course, to make. But most importantly, this author has personally attended hearings at Sharia councils in Birmingham, London and Nuneaton. The book is also extensively footnoted, about 27 pages of bibliography at the back, with references to a surprisingly broad range of published research into this, what it can, I think, be rightly said, even with balance, as an increasingly vexed area, because there are concerns. In particular, there's a reference in the book's third chapter which catches the eye and should definitely be of interest to family lawyers, referring to such problems as discriminatory practices on the part of fundamentalists towards Muslim women, seeking, for example, to divorce, including, note, marital captivity and honour-based violence. And a Yemeni-Swiss political scientist, Elam Manea, is quoted as follows, quote, "These voices are actually calling for the legitimisation of systematic discrimination against women and children, and such discrimination will certainly not help any successful integration of migrants' communities of Islamic faith. Indeed, it will only lead to the cementation of closed parallel societies with two types of women: Western women who enjoy their rights according to the state's laws, and migrants women who do not." Interesting point, very topical at the moment, as I'm recording this in the early part of 2016 as we build up for an election in May in London, and then the referendum on EU membership, which is mainly, in many areas, about migration policy. So these comments, I think, are valid because there are very grave concerns about what is happening. And with these comments in mind, then, Western governments and policymakers must therefore, we suggest, ensure that communities of Islamic faith in their midst, especially women, are protected at least by education and widespread information about what their human rights are in a free society, with, let us hope, one law for all, and also, let us hope, some fierce no-nonsense legislation, perhaps on lines such as Canada's aptly named Zero Tolerance for Barbaric Cultural Practices Act 2015. It's important to note that these are cultural and not religious practices, and I think there's an important point, perhaps from the point of view of the Islamic cleric, to take that point on board, and it's only a submission. Obviously, it's something I think in a free society is worth at least exploring. Canada, of course, is a traditionally tolerant country with vast numbers of immigrants and a history of their successful acculturation, which has finally got fed up to the back teeth with tolerating the intolerable and enshrined in a specific piece of legislation its abhorrence of such odious practice as forced marriages and domestic and so-called honour violence. "We will not tolerate violence against women and girls" is one of the key clauses to note. Now, I'm sure that it is correct to say that that is a view expressed also within the EU and in Britain itself. Whether it's actually embodied in law is another matter, but it's certainly a basic principle that we have in this country, and it's sobering therefore to be reminded quite frequently in this book of the fairly recent public utterances of two towering figures in respectively the church and the law in the United Kingdom. One is the former Archbishop of Canterbury, Rowan Williams, and the other is Lord Phillips of Wortham Travers. Each of these worthies has argued basically in support of the need for Muslim minorities to have their own legal institutions based on laws that follow from the Islamic religion. And there are lots of links, of course, in the footnotes to that. Now, that is an issue for discussion. And I will say now, and I'm sure a lot of members of my practice, the bar, my profession, the view is that we have the common law. And the common law, including equitable principles, is the basis upon which the rule of law derives. Now, I cannot see that altering that is going to help matters personally, but I may be considered old-fashioned, but I do not think that there is a place for tinkering with it. And that is all I will say on the matter, because I'm sure this debate will continue. And I'm well aware that there are a lot of people in practice at the bar who don't actually agree with either Rowan Williams or Lord Phillips. Many have argued that this concept is in itself, of course, a form of discrimination, with large numbers of adherents of a particular religious faith virtually excluded from the traditional protections afforded by the rule of law. Could this be a recipe, of course, for creating closed parallel societies with two types of women as a result of two parallel systems of law? Well, it didn't happen with common law and equity, is all I would say, to balance it the other way. But however, one would hope that neither Phillips nor Williams would really want this sort of thing. Well, not really. The point is that the development of the common law and equity are seen in a very different way from the sort of thing that we're talking about here, with the common law being amended to take account of Sharia. Now, let me conclude by saying that the author nonetheless implies that multiculturalism has become a political ideology, and to some an attractive one. The consequences, dispassionately argued, are based on field study as well as published research. So perhaps with a slightly different title, it's called Choosing Sharia, this book might just end up as a bestseller and acquired by university and legal libraries everywhere. Well, I certainly think that everybody should read this book. It's not the easiest book to read, but it's a very important book as we form what we're going to be doing for the rest of this, certainly this decade and this century. The publication date is cited at 2016. Let's have a quick look at it again. Paperback, there's the front, spine, and then you've got a picture of match 10 at the back there. And then just opening it up in the middle, I'm opening it here, for instance. This is in part 3, when multiculturalism and Islam fundamentalism coincide, Sharia councils in the UK. That's really what we're referring to. And the question really is going to be the growth and what's going to happen to that. You can see the footnoting there. You can see some subheads used. The content, for instance, Rowan Williams is mentioned on that page. The content is very deep. But what she has done, what Dr. Z has done, is she has, for every point made, she's put forward a justification for the assertion, which is the correct way to deal with these things. It's a high-level book, and I really would like to thank Eleven for having the courage to publish it. This is not an issue that's going to go away, and I'm glad that at least the debate is open. I'm also very concerned specifically about the role of vulnerable people, women and children, in this equation. So one can see where the publishers and where I am, and certainly my wife Elizabeth, are coming from with our review. Thank you anyway to all concerned. Bye-bye.